Longoria.
Present.
Vice Chairman Vasu.
Present.
Representative Niave Corrado.
Here.
Representative Lambert.
Present.
Representative Hinojosa. Representative Gonzalez. Representative Cole. Representative Isaac. Representative Frazier.
Here.
Quorum is present.
A quorum is present. Members, I want to thank each of you for being here today, as well as members of the public that are watching both in person and online. As a reminder, anyone present wishing to testify before the committee, please register at the iPad kiosk located in the hallway behind the hearing rooms. If you require assistance in registering to testify, please contact our committee staff. I want to make an announcement regarding today's agenda. House Bill 207 by Murr will not be heard in the committee today at the request of the bill author. There will be no action taken on House Bill 207 in today's hearing. I also want to mention that it's the chair's intention to hear House Bill 4 last in today's agenda. Members, any questions before we begin? If not, the chair lays out HB 1558 relating to the extension or amendment of deed restrictions in certain older subdivisions by Representative Ann Johnson.
Good morning, Chairman Longoria and Vice Chair Vasu, honorable members of this committee. Thank you again for consideration of House Bill 1558. This is a refile from last year. This bill was passed out of this committee unanimously, passed out of the House on local and consent, and died in the Senate on the last day. What this bill seeks to do is allow older subdivisions to be able to modify and change their deed restrictions, specifically in Houston, where we do not have zoning. And so this would allow for the city of Southgate and that community to amend their deed restrictions to take out old, out-of-date language.
The chair recognizes Representative Cole.
And we have worked with stakeholders on this bill to ensure that those changes would only happen once every 5 years. We've also worked for notification requirements for the community and to ensure that the community vote would be over 66.6%. Again, I appreciate the opportunity for this community to be able to control the value of their property and modifications that can be made in current times. And I thank the chairman and believe we have Edward Aviles, who has registered a resident of the Southgate community that has been part of the drafting of this bill, to answer any additional questions and to also provide testimony.
Members, are there any questions for Representative Johnson? If there are no further questions, we'll proceed to testimony.
Thank you. And I'd ask to reserve the right to close.
Thank you. Chair recognizes Representative Hinojosa is present. Chair calls Edward Aviles. And we show you registered as Edward Aviles on behalf of Southgate Civic Club and self testifying for the bill. Is that correct?
That's correct.
Thank you.
Thank you very much. Thank you, Chair Longoria, and thanks to the committee for allowing me the opportunity to speak on behalf of this bill. My name is Edward Aviles. I'm a resident of Southgate neighborhood in Harris County. I'm also an attorney, and I've worked many hours pro bono on this bill over the last couple years. The purpose of the bill, as Rep. Johnson stated, is to allow older neighborhoods platted before 1947 that do not have mandatory properties owners associations the ability to amend or extend their deed restrictions. Because Houston doesn't have zoning, deed restrictions are the only viable way to restrict land use and construction. Older subdivisions in Houston with very basic deed restrictions lack, the deed restrictions for Southgate are essentially one page. Newer subdivisions often have deed restrictions that are 20 or 30 pages, and Southgate and some other neighborhoods are just looking to be on a level playing field with other neighborhoods that have more modern deed restrictions. Another big reason for proposing a bill of this nature is to have the ability to stop developers from coming into our neighborhood and taking 3 or 4 multifamily lots on the fringe of the neighborhood and building a 20-story high-rise residential building in the middle of a residential neighborhood. So those are the kinds of issues that this bill would address in allowing older neighborhoods to amend their deed restrictions. The current property code has some chapters that allow neighborhoods with mandatory homeowners associations the ability to amend their restrictions, but because we are a voluntary HOA, we can't avail ourselves of those chapters, and we don't believe it would be viable to create a mandatory HOA in the neighborhood. The bill does require a 2/3 vote, 66.6% to pass, and only applies to Harris County to subdivisions that were platted before 1947. And that's all I have. we hope that you support this bill.
Members, any questions? Well, thank you.
Thank you very much.
Is there anyone else who wishes to testify on, for, or against House Bill 1558? If not, the chair recognizes Representative Johnson to close on HB 1558.
Thank you again, committee. Thank you for your consideration of this bill again this session. I expect that the Texas Association of Builders is also going to drop a card in favor of it, and this would allow for this community to protect their interests and their property value. So thank you again. We hope that you will pass it favorably.
Thank you. If there's no objection, the bill will be left pending. Is there objection? The chair hears none. The bill is left pending. Chair lays out House Bill 614 by Shaheen relating to Property Owners Association fees. Chair recognizes Rep. Shaheen. Explain the bill.
Thank you, Chair Longoria, Vice Chair Fasut, and members. House Bill 614 requires better transparency of HOA policies and fines. There have been many examples of homeowners being surprised by unnecessary policies and excessive fines throughout our state. HOAs can push through rules or create new ones without the approval of a majority of homeowners, so long as the changes pass a quorum vote. HB 614 will require HOAs to provide a copy of their policies and fines to property owners by either posting it on their internal or internet website or annually sending a copy via mail or email to their homeowners. HOAs would also be required to categorize their restrictive covenants to make them easier to understand. So these categorizations would include property maintenance and repair, individual misconduct, or matters affecting health and safety. With that, Mr. Chairman, I'm happy to answer any questions and reserve my right to close.
Representative Cole?
Did you say they're able to pass rules based on a quorum vote and not a majority?
Quorum vote of who's present at the meeting and not the majority of the homeowners.
Members, any questions for Representative Shaheen? Now we'll proceed to testimony. Thank you. Oh, Representative Lambert.
Thank you, Mr. Chairman. Representative Shaheen, we passed the HOA reform bill last session, which was a pretty omnibus bill, but can you kind of tell us a little bit about some excesses that you're seeing happening out there in HOAs that requires this kind of tightening up?
Yeah, I mean, there's a HOA not in my district, near my district, that had a $1,000 fine if you parked your vehicle in your driveway. There was a homeowner that was actually forced. This was in South Texas, I believe, was forced to actually join a HOA. So when they bought their home originally, it was not part of the HOA. Then they were then forced to be part of the HOA. That's before the Supreme Court right now. That they're at threat of losing their house because they're not complying with HOA rules. There's a couple in Cyprus sued for $250,000 because they were feeding birds. There was an individual in one of the cities that I represent. He was in the military. He gets deployed overseas, come back, and there's a lien on his house. So I think if we could just, and there was some great work done last session on HOAs. I think if we just had this additional step of transparency, I think it would go a long way in helping our constituents.
I appreciate the transparency issue being addressed to some of the smaller HOAs, maybe in some rural areas aren't quite as organized, and so being able to offer it either through social media or internet or some kind of written notice, I think is important. I was reading one time about somebody, I guess, maybe built a fence all the way down their property line, even across the sidewalk where people were trying to get across. So there are some real problems out there. So, thank you.
Thank you, sir.
Vice Chair Vasut.
Is there any maximum fine in Texas law, where we set a ceiling on how much of a fine an HOA can assess? You aware of anything like that? I was just thinking of it.
No, and there's not to my understanding, and there's a presumption in current law that the fines are reasonable.
Okay.
So if you were going to go to court, you actually have to demonstrate that the fines are not reasonable.
Understood.
Thank you. Members, any questions? Thank you, Representative. We'll proceed to testimony.
Thank you, Mr. Chairman.
Chair calls Kim Pollock, and we showed you registered as Kim Pollock on behalf of Texas Community Association Advocates and self testifying against the bill. Is that correct?
Yes, sir. Good morning.
Morning.
My name is Kim Pollock, and I'm testifying on behalf of Texas Community Association Advocates, known as TCAA, in opposition to parts of the bill as filed. I recently served as the president of my homeowners association in Las Colinas, Irving, Texas, and our board effectively and efficiently used fines to convince owners who were in violation of covenants to cure the violations. Because of our ability to use the fines, we did not have to hire lawyers to file lawsuits and spend a great deal of money to get the violations cured. Fines are a tested, inexpensive, and reasonable way to seek enforcement of our restricted covenants. Most of all of our violations in my community were cured after sending the notice to owners about violation. But keep in mind, most violations are discovered when other owners report the violation to the board. And as a homeowner, I expected the board to enforce the restrictions and covenants. When I was president, it was my duty to seek enforcement. So speaking from experience, my neighbor's violations occurred, and I expected the board to seek correction. The critical problem with this bill, and as I see it, and as who I represent sees it, is that it requires volunteer homeowners who serve on their boards to identify each category of restrictions or the rules for which the violations may be levied. Each category. This requirement is onerous, if not nearly impossible, to accomplish with reasonable accuracy. The current proposed language will cause confusion and potentially put HOAs at risk for expensive lawsuits from homeowners. As written, the bill would force boards to create separate fine categories in their policy for maintenance violations, personal misconduct violations, health and safety violations, etc. This is very challenging because it's impossible to anticipate every scenario that may result in a violation. So specifically, the bill sets up HOAs for lawsuits and other problems by opening the door for owners to argue that the specific violation they committed did not fall into a specific fine category. That language, fine each category. So thus the fine could be invalid. So if, for example, an owner installed solar panels without the architectural review approval in violation of legally adopted solar panel restrictions under Chapter 202 of the Texas Property Code, the community expressly listed a category of restrictive covenants for which fines could be assessed, the installation of improvements without architectural committee approval. But the board did not specifically list solar panel violations, so each category of violation, remember, so the owner could challenge the fine because the community failed to specifically include solar panel violations as a restrictive covenant. Another example, the community lists individual misconduct, which is listed in the bill as a restrictive covenant for which fines may be assessed. The owner has a party, this happened next to me, and is cited for violation of the unreasonable noise and nuisance restriction in the declaration. The owner might challenge a fine imposed because the fine policy did not list unreasonable noise and nuisance restriction. So the point I'm trying to make is that listing each category of restricted covenants for which associations may assess fines is nearly impossible to accomplish. It's difficult to identify and leaves way too much room for legal challenges. Many communities like mine rely on the ability to fine in order to cost-effectively and fairly enforce our covenants. This regulation of fining will also serve as an invitation to lawyers to exploit indigenous interpretation anomalies in the statute. Importantly, trying to prepare this fine policy to comply with these rigid requirements will be expensive for communities. Finally, the bill requires all POAs to adopt a fine policy regarding levying of fines. regardless of whether the POA's governing documents already allow for fining and provide a fine schedule with amounts. We should not need to prepare a separate fine policy if the fining rules are already included in a recording governing document. So we do want to complement some aspects of the bill. We always send notification to owners of new policies before we enforce them, but here we like the expanded methods of notification. So TCAA has provided alternative language that we think will make this bill acceptable to all. So we request that you look at and consider TCAA's proposed language for the bill. Thank you for your time and allowing me to be here.
Thank you. Members, any questions? Representative Cole.
Can you explain what the proposed language would do?
The proposed language of the House Bill 614.
The proposed language to the category requirements that you're objecting to.
Well, the proposed bill says each category of fines has to be identified. And it lists 3 and then says, et cetera. That leaves a very wide, it leaves it wide open for interpretation.
So you would like the et cetera removed?
Each category. We have provided proposed language.
Okay.
Okay. Thank you.
Thank you, members. Thank you. Is there anyone else who wishes to testify on, for, or against House Bill 614? If not, the chair recognizes Rep. Shaheen to close on HB 614.
Thank you, Chair. Let me read the statute on the item of categorization, just so it's very clear what the bill says. I didn't use the word et cetera. Are you allowed to use et cetera in a bill? Here's what it says. It says, this is on the categorization of the fines. Each category of restricted covenants for which the association may assess a reasonable fine, including, and then it mentions those 3. If there's a concern that that's difficult, and I think that's a reasonable expectation, that's how we do state law, the 4th category can be other. And so I don't see a scenario where, because fines were not categorized, that's going to give you some kind of ability to sue an HOA over a fine because it wasn't categorized. I don't really see that scenario. It's very reasonable to ask for categorization. I don't think that's a big Herculean effort. Again, we categorize the statutes that we work on. So I am more than happy to work with everyone and anybody on the bill. I have not seen any proposed language, but once we get that, we're more than happy to work with anybody that has any recommendations for the bill. But I just want to be clear, and again, the way the bill is written, it just asks that those 3 categories be included. They can have all the other categories that they want. And again, if there's a concern, just have your other category as other. With that, Mr. Chairman, if there's no other questions, I close.
Representative Frazier.
Chairman, thank you. And Representative, thank you for bringing this up, especially in our area where we have so many different HOAs that have all different rules and regulations. We never know which one's going to hit with somebody with something. Do you have any, has your team looked at how many fines have been collected by HOAs throughout the state of Texas?
No.
I would love to know that
Yeah,
number.
I would too. I might have to do that.
Yeah.
They're listening right now, so I think they're going to
I
start
think
working.
they are listening. I think that would be a nice number to throw out to the public, to what the actual fines are for the entire state of Texas of HOAs.
Yeah.
Yeah, anyway.
Well, I know because of your city council experience,
Yes, sir.
you've dealt with it.
Yes, sir. Anyway, thank you for bringing this bill
Thank
forward.
you, sir.
Members, any questions? Thank you, Representative. If there's no objection, the bill will be left pending. Is there objection? Chair hears none. The bill will be left pending. Thank you.
Thank you, members.
All right. Chair lays out House Bill 471 and recognizes Representative Patterson relating to the benefits for certain first responders and other employees related to illness and injury. Representative, please explain the bill. Oh, Representative Lambert offers a committee sub for HB 471.
Thank you, Mr. Chairman, Vice Chair Vasut, and members of the committee. First off, I've served on this committee for 2 sessions, and I miss this committee. It's a great committee. You see a lot of different things from what you've heard already this morning to what I'm going to talk about. And before I get into my prepared remarks, I want to be very clear about what we're talking about here with this bill. We're talking about firefighters, police officers, and EMS professionals who are injured in the line of duty and cannot, due to their injury, get back to work in a very quick fashion. So we're talking about folks that are running into danger and getting injured while they're there when they were sent in by a city council or a city manager, sent into danger, they get injured and can't get back quickly to their jobs. Should they be at risk at losing their jobs because of doing the duty that they were asked to do? And so I have some prepared remarks here. Thank you again for the opportunity to lay out the committee substitute for House Bill 471. This bill is an effort to ensure that first responders are taken care of when they are stricken with on-duty injuries and illnesses. It has become a collaborative effort between many of the stakeholder groups, including the risk pools. It's a breath of fresh air, I can assure you, having worked on this for multiple sessions, and a big change from years past when many of these groups were absolutely opposed to any changes whatsoever. So we've really gotten a good group together. The first problem this bill seeks to solve is ensuring that first responders who are injured on duty keep their jobs with pay for at least a year while recovering. Most or all of this pay is going to be coming from workers' compensation insurance, as it always has. The genesis of this idea was when my constituents and local Frisco firefighters came to me with an issue of their members that were severely injured on duty, receiving letters that in short stated, "Get back to work or you're going to lose your job." The first section of the bill also gives employees and employers multiple options, including light duty and even temporary retirement if appropriate. Last session, I filed House Bill 2242, which addressed this very issue. The bill passed the House, but ran out of time on the Senate side. The committee substitute to House Bill 471 does delete one section related to the lifetime income benefits that was in the original bill. The issue is still being negotiated by first responders and insurance providers, but it does exist in a standalone bill by Chairman Burrows, which you may or may not hear later. The next section in the bill relates to Chapter 607 of the Government Code called the Presumptive Act. This chapter concerns diseases and medical issues that are presumed to have been caused by a first responder's duty and do not require them to show cause. This chapter of the code went through a major modification in 2019 that resulted in cancer denials going from more than 90% to less than 40%. So just to highlight that, we took denials of first responders who get cancer in the line of duty down from 90% to 40% denials. So significant improvement that the legislature made for our first responders there. Nevertheless, some roadblocks still exist and cause confusion. Therefore, stakeholders worked hard on the substitute, and the new definition is a person that, and this relates to the tobacco clause, that a person that regularly uses tobacco in the last 7 years versus the ambiguous nature of the code today. Both sides worked in good faith on this negotiation. A heavy smoker requesting coverage 2 years after quitting seems questionable, but a person that smoked just one cigar to celebrate the birth of a child should be able to receive cancer coverage. The final section relates to heart attacks and strokes. First responders have faced difficulties getting coverage under Chapter 607 when suffering from these medical events. Under current law, a first responder has to have the actual medical event while on duty. And if you have a heart attack 5 minutes after your shift is over, it would not be covered. So this section of the bill stretches the time out to 8 hours after the end of a shift. An increase in post-duty coverage will go on to better protect first responders and their families. I believe we do have witnesses here today from the Frisco Firefighter Association and also general counsel from the Texas State Association of Firefighters to speak more in depth on the ways this legislation solves a myriad of problems. Despite the fact that I filed this bill in November and have worked on this for many years now, some groups will oppose after supplying me language just a couple of business days ago, I'm sure. They've refused to show me evidence that this would impose any real costs. And in fact, any of y'all that have civil service contracts on your local fire departments, they already have the 1-year benefit as well. So We haven't heard any issues with that. Members, I'm happy to take any questions that you have and would reserve my right to close.
Thank you. Representative Hinojosa?
Thank you, Chairman. Thank you, Representative, for bringing this bill. I like what you're trying to do. I have specific questions about how you're doing some of this. There's two sections, well, and I don't know if this is in the substitute because I haven't had a chance to read the substitute, but in the original bill, there's two sections that say if the firefighter doesn't take, the firefighter can either take sick leave, vacation time, or have a temporary have a volunteer person fill in temporarily. And there's two sections that mention somebody can voluntarily step in. And it seems to be that the firefighter or the employee can choose. So I have questions about that because I don't know who's volunteering, what their qualifications are. It seems like the institution should have a say.
Yeah, no, I completely understand. So basically, here's the deal. State employees currently, so A&M folks, TxDOT folks, DPS folks, they can all, at the end of their leave, when they're injured, they can have people volunteer for them, they can use their sick leave to extend their time off after the fact. So that's one of the things that you mentioned. That's already for state employees. DPS troopers already have the full year off if they're injured in the line of duty as well. What you're specifically referring to there is I've got the full year to get back to work. You know, I've been shot. I've broken my back, fallen off a ladder, you know, on the side of a house. I've been hit by a car on the highway while we're working a wreck. I've got a full year to get back to work and all that. If I can't get back during that time and I have accrued sick leave, I can then extend that time through my sick leave that I have accrued. I can have other like professionals within the organization volunteer to take my shifts for me. So if I'm a driver on the fire department, or if I'm a paramedic, or if I'm an investigator, I can have someone that is a like job role within the community, within that same department, fill in for me for shifts that I may not be able to do. We see this sometimes with teachers. You know, you may see where they have a cancer diagnosis and they're out, and you'll see other folks kind of try to make up their time or do things. We see this in a number of different professions. So that's all we're trying to say is if you're a firefighter, another firefighter within the same department, it's not a random person, but another firefighter can do your job for you. It would not allow a regular firefighter or paramedic to take a battalion chief's position for them. It would have to be like positions.
That wasn't clear to me in the bill, but I'll just follow up with you after
Sure.
to better understand.
If we can clean
But I
that up,
appreciate it.
by all
Okay.
means.
And then the only other thing is there's a section in the original bill that says you have a year and then a determination can be made about whether you get another year. And then if you don't get another year, then other things kick in. But what I don't see is for that second year, any kind of determination being made that you still need it. And so is there some review of your condition and circumstances to verify that you still qualify for that?
Yes, ma'am. So, and that would also be up to the city on whether or not they extend you for another year as well. So the city has the right then. I mean, you got to cut off at some point, right? There's got to be a conversation at some point that says we're not getting better, perhaps. And in the bill, it says you can medically retire, you can do different things, right? At that year point. But what we don't want to happen is what happens in some communities, which is if you're injured in the line of duty after 90 days or after 6 months, when the federal protection is going, you're out of a job. You're done. And you were just doing your duty. You just went to work that day and you're doing what you signed up to do and you know the risks. But at the end of the day, if we're going to send folks out into harm's way, we need to make sure that they've got every opportunity to get back to work. And I'll say this as well. The workers' compensation process, the games that are played with some of these folks, these men and women that serve in these positions, is ridiculous. There are times where they can't even get in to see the specialist that they need to until toward the end of the life of the time that they have here. So let's say that they know that they need surgery to address something on their back. they may not even be able to get in and get that surgery. And I believe, actually, I don't want to steal the thunder of one of our witnesses, but they may not even be able to get in to get that surgery until 6 or 8 months goes by. Then they've got the rehab schedule. So we're just trying to say, we're giving you plenty of time to get things figured out, to get life figured out. You can take a light duty role within the city. There's a lot of different things that you can do. There's a lot of options here if you can't get fully back to work, but we're going to give you a year to try to get there.
And I see that the language says that the municipality may extend, but then it says if it's not extended, the person is considered eligible to receive the disability retirement benefits until
Correct.
the return of duty. So I just wonder if there's some way that it seems like an automatic without an evaluation of the condition of the employee.
Yeah, and keep in mind, I mean, they're evaluated all throughout that year. It's not like they get evaluated on day 2 and then nothing's done. I mean, there's updates and doctor's visits and that sort of thing. Yeah, I mean, you've got a full year, but the city's got a decision to make at that point, after the year.
Okay, thank you.
Thank you.
Representative Frazier.
Representative Hinojosa, I'll kind of clean up a little bit of this because I've been in this situation for our officers for many years. So Representative Patterson is really explaining it pretty close to almost 100% accurate. When you have an injured officer or firefighter, they may not get into the doctor 6 months down the road. And then they have that rehabilitation time. And it's a game that worker comp plays. We've all known it. It's being documented every day. You can have a SWAT officer wants to get back and has a broken ankle, and he doesn't get to see that doctor, get that pin in his leg for 6 weeks after the accident, which most folks would just have the injury. Then there's a rating process that comes after that the workers' comp does. And I think when we had workers' comp in here last week, we solved part of the problem with their liaison issue, where they have one liaison for the entire public safety for the state of Texas. And that person was supposed to clean that up for us. I think it was 3 sessions ago when we put that liaison in play, and we kind of see that there's a much need right there to expedite this process. And he's doing a great job. I think this is a great start to where we need to be at. But that's what's been happening for all these years with these folks. They don't want to be off. If anyone says that, that's the biggest misconception, because they're losing money. Every day that they're on the beach for this injury, they are losing money, and they need to get back to work for their family. So this bill will especially expedite that and clean up some of the things where some of these departments just want to get rid of them and move another person in there. So that's just a simple truth.
Representative Lambert.
Thank you, Mr. Chairman. Thank you, Representative Patterson. And again, I reiterate the fact that we passed this bill last session, and it just got held up basically on the other side. I had one constituent reach out that was concerned that some of the changes you've been working on since November might open the door for a broader interpretation about who actually is affected by this. Can you just restate again, this is just primarily for first responders?
Yes, sir, absolutely. And in fact, there's a few definitions here at the start of the bill. So emergency medical services personnel, which is already described in the Health and Safety Code. Firefighters, which is a permanent paid employee. So, my dad was a volunteer firefighter for a long time. He would not be covered, under this. And then, police officers. So again, another paid employee who's a full-time, who holds an officer license in the occupation code. Those are the folks that we're talking about. We're not talking about anything outside of that. And again, DPS troopers at the state level, they already have many of these same protections, especially the 1 year to get back to work. They already have that. And some of the other provisions here, state employees already have some of these other provisions that are in this bill. And I'm not trying to pit one person against each other, but somebody that works in a cubicle all day doesn't have the same risks to their job as someone that is running into a burning building or working an accident on the side of the highway when people are texting and driving, or certainly someone that's going into a bank robbery with bullets flying. So we're just trying to basically get these folks that are literally risking their lives, and don't mistake this, their families' fortunes, because if something happens to them, this is a generational impact on their families. We're just trying to get them up to the same levels as someone that's in payroll at Texas A&M.
Thank you.
Members, any questions for Representative Patterson? All right, thank you. We'll proceed to public
Thank you.
testimony. Chair calls Bennett Sadlin, and we showed you registered as Bennett Sadlin on behalf of Texas Municipal League testifying against the bill. Is that correct?
Yes, sir. That's correct. Good morning, Chair, members of the committee. I am Bennett Sandlin, the Executive Director of Texas Municipal League. I want to thank you for the opportunity to testify on this bill. We are against the bill, but I want to tell you only because of Section 1. We are supportive of Sections 2 through 4, which are the improvements to the workers' comp presumption law. Thank you to Representative Patterson's office for taking our input on this, our risk pools input, and we are proud of the negotiations that improve the sections on tobacco usage. We agree that if you ever use tobacco in your lifetime, that's probably too strict to exclude you from a cancer presumption. And the heart attack, we recognize that heart attacks don't always happen, while fighting a fire. You might go home and 5 hours later have a heart attack. So these two negotiations greatly improve those sections. Our only concern with the bill is Section 1, which is the paid sick leave or injury leave that's currently mirrored in the civil service statutes. The problem with this is it's duplicative of workers' comp. You already get income benefits and more under workers' comp. So you may say, what's the problem with having the same benefit available, as just out-of-pocket paid sick leave? The problem is paid sick leave doesn't work for small cities that can't afford it. The difference is comp is covered by insurance. So when you have to pay income benefits to a firefighter, you're insured for that through the TML risk pool, another risk pool, private insurance. But the paid sick leave you pay out of pocket. Now that may be appropriate for large cities, and that's why this benefit is already available only to the 107 large cities that have civil service. Excuse me, my throat is raspy today. Those cities do get this benefit, and those firefighters can choose the sick leave, or they can go through the comp system to get their paid benefit. And that may work for a larger city. Small city, it doesn't work so well. Let me give you an example. Let's say you've got 5 paid firefighters, and that's all in a very small city. One of those firefighters gets an illness, on-the-job illness, and has to be out a year. If you have to pay that out of pocket to the city, they're not going to be able to replace that firefighter. Those other 4 firefighters are going to have to pick up shifts, work 20% harder, because the city literally doesn't have it in their budget to replace that 5th firefighter. That's why comp is better. That city does have to have workers' comp insurance, and so we're going to pay those income benefits through comp. That frees up the city to hire a temporary worker to replace that firefighter for that year. That way the city's covered. So all those small cities pool together. They're not all losing a 1/5 of their force each year, so they can afford to help the city down the road meet that benefit. So comp is a better solution for smaller cities. Now, to the representative's point, if the issue is that firefighter doesn't get his job back at the end of the year, that's a problem. And we'll work with the representative to either make sure that's the case under comp or a standalone law that says you can't be fired for coming back after a year. But we're just saying it's cost prohibitive for a small city to have to pay this benefit out of pocket when it's already being covered by insurance. And insurance is better for that. The paid sick leave benefit is not insurable, at least not at present. So this is a benefit that does mirror something that's under civil service. Civil service is only available for cities over 10,000 population, and then only for cities that have had an election. So civil service is such a comprehensive scheme that we make the voters go to the polls and say, that's right for our city. So Austin has it, other cities have it. Most small cities do not. 931 cities are under 10,000 will never have civil service, and that's probably appropriate. But they're going to get this civil service benefit under Section 1. On paper, it looks great. I wish we could do that for all employees, but we can't afford it, especially in a department of 4 or 5 where you cannot replace somebody that's injured or sick. Comp allows you to do that. The standalone benefit in Section 1 does not. That's our concern with it. We'd love to offer it. It's cost prohibitive. And by the way, comp is getting better every session on these diseases of firefighters and police officers. As the Representative Patterson pointed out, last session we made a big improvement. We immediately added COVID as an automatic comp presumption. You don't have to prove that you got it on the job. And 2 sessions before that, the TML risk pool negotiated to agree to expand cancers from 3 to 11. And we pledged this committee, as science changes and we realize that more diseases are caused on the job, particularly firefighting, but also EMS and sometimes police, we will work with Representative Patterson to add those diseases and situations to the comp statute. Comp's not perfect, but it's the only option that small cities have to temporarily replace a sick firefighter or police officer. So again, we're supportive of 3/4 of this bill. This first section is cost prohibitive for small cities. And that's our testimony. I'd be happy to answer any questions.
Representative Cole?
Will you support paid sick leave being part of workers' comp?
Absolutely. And it's in there in the sense of income benefits. You do get them, but you're insured for them. So yes, absolutely. I don't want those peace officers or firefighters to miss their salary, but it's important where it comes from. If it comes from comp, the city's covered because the risk pools protect them and insure them. If it comes from the paid side of Section 1, it comes out of the pocket of the city. They don't have insurance for that, and they're going to be left with a missing firefighter for a year. And that's the only concern we had with it.
Representative Frazier?
Thank you for the testimony. They don't get both, right?
Well, interestingly, they can under this bill, and I think that's just an oversight. You can't get 143 civil service paid leave and comp because there's a section in the Labor Code, and I'm going to point this out to Representative Patterson, but it's not the reason for my testimony today. But Section 504.051 of the Labor Code requires the firefighter to pick one or the other under 143 or in any law that was in effect as of 1975. So that section needs to be amended. If we do go through a Section 1, it'll need to be amended to show that this law, too, creates an offset or a choice. I didn't bring that up in my testimony because I don't think that was intentional. I don't think the intent was to double dip, but I just wanted to point that out. They should not get both.
Yeah, they won't get both. It's either one or the other. But you do agree that an injured firefighter or a police officer should get what they need for doing the service that they're serving.
Absolutely.
Whether it's
Including
a
their salary.
5-man department or a 1-man department.
You bet.
Yeah, so
Yes,
I think
sir.
that solves it right there.
Yes, sir.
Thank you.
Members, any questions? Thank you.
Thank you.
Chair now calls Matthew Sapp. And we show you registered as Matthew Sapp on behalf of the Frisco Firefighter Association and self. Is that correct?
Yes, sir.
And you'll be testifying for the bill.
Yes, sir. Chairman Longoria, committee members, thank you. I was going to start with something else, but I'd like to make a couple points after what the TML executive stated. So, Section 1 is quite important of this bill, especially if you factor in that they're okay with other sections, such as the extended hours for cardiac, so a heart attack. I'll use one of our examples that I was going to tell you about later, but I'll start with that. Jeffrey Stowe worked 48 hours, fought a structure fire at 2 a.m., left the station at 9 a.m. rolling down Main Street, had a heart attack and died. 28 years old. Took him about 11 months to get back, and the city did not allow him back. What they said was he had a level A restriction, and they were not going to reemploy him as a firefighter. They said, you can take another job, or you can, here's what COBRA costs. We lovingly refer to those as last chance letters. Jeffrey is now a captain in Northwestern Hills. So my point to that is that if you're in favor of part of this bill to provide better protections, then you have to allow us the time to get back to work. About 4 years ago, I approached Representative Patterson to discuss some of the issues we were having. He is our representative of our district. I'm also a constituent in his district. So about 4 years ago, we had a firefighter that was denied occupational cancer diagnosis. It took us about 1.5 years to get it cleared for occupational. Workers' comp made all the reimbursements, the necessary time for him to get back was past the year. He got a letter. Now, he was never able to come back just due to the illness. Another instance that we had that resulted in us finally coming to Jared was a female firefighter named Shannon Biggs broke her back. As Representative Patterson stated, getting through workers' comp is fickle. It took her 10 months to get to the surgeon to have the surgery. So she had a broken back, broken vertebrae, And shots and therapy is what workers' comp said she needed. That's crazy. I'm a paramedic. I know that doesn't work. Bones don't heal with therapy and shots. She had the surgery on month 11 while she was waiting to go back for her post-op appointment. She was given what we refer to as the last chance letter. Come back to work, or you can find another job within the city that will be about a $30,000-$40,000 pay cut, or here's what your COBRA insurance costs. She hasn't even seen her post-op visit yet. She asks what else she needs to do. Oh, well, you can fill out the paperwork for ADA. Well, ADA is great, but I'm not going to be able to get an ADA clearance to ride a fire truck. I'm not going to be able to get an ADA clearance to be a police officer on the street. That's what this bill intends to do. Ma'am, you had asked about other employees working. So when I was 27 years old, I got sick. It was thought to be an adrenal tumor. I ran out of sick time. My city did not have something like this in place, but we were allowed to, what we do, blind trades. So another firefighter that meets my rank as a firefighter paramedic can ride my seat, and I get my paycheck. That's the same thing this bill is doing. And as a matter of fact, what that does is it establishes a way for that employee to continue to offset the 60% that workers' comp gives to make them whole at no cost to the citizen. That's no cost to the taxpayer. And most of us, Representative Frazier, you're a police officer, we will work for our brothers and sisters if they need it. There's no question. I would hope that this makes it through committee. As Representative Patterson stated, this made it through the committee. Last time, it just ran out of time in the Senate, and I would be happy to answer any questions, and thank you.
Members, any questions? Thank you. Chair now calls Matt Backhop. And we show you registered as Matt Backhop on behalf of the Texas Association of Firefighters, and you will be testifying for the bill. Is that correct?
That's right. Good morning, Mr. Chair, committee members. As Representative Patterson mentioned, this bill is about who bears the burden of first responders getting hurt on the job. Under this bill, the people who are served by the first responders support them when they get hurt by paying their full salary, instead of the current system in many cities and counties where we punish the first responders by cutting their pay and putting their jobs in jeopardy when they get hurt on the job. As you've heard, the benefit that this bill would provide has been available under the Civil Service Act, which covers over 100 cities, and it's been available since that law was passed in 1947. And so we have over 75 years of history of this benefit working well in those cities. And in practice, it is always used in conjunction with workers' comp. And it's a supplement to the workers' comp benefits to get the injured employee up to 100% of their pay. And to answer Representative Hinojosa's question, there's an allowance under the Civil Service Act also for peers to step up and take on shifts, but that does have to be approved by the department head. It's not like the injured employee gets to dictate operations in the department and who works what shift. This benefit has been used regularly in civil service cities. There's been very little litigation on it. TML says small cities can't afford it, but those cities have already budgeted to pay 100% of the salary. And this bill would only move them from paying 0% during the period of injury to paying the small fraction that's not covered by workers' comp. The idea that this would replace comp is disingenuous. We've got a long history. These benefits are always used together. We think this supplement to workers' comp should be extended to all county and city first responders across the state. And thank you for your time and allowing me to provide testimony.
Thank you. Members? Thank you very much. Chair now calls Chris Jones. And we show you registered as Chris Jones, Director of CLEAT, Combined Law Enforcement Association of Texas, testifying for the bill. Is that correct?
Yes, sir. Thank you, Mr. Chairman, members, for having me and hearing this bill. Also want to thank Representative Patterson for carrying this legislation and also working diligently with the stakeholders to try to work out some of the issues that the bill is addressing. That's always a challenge. I represent CLEAT. We represent over 27,000 peace officers in Texas. I want to address first something Mr. Sadlin said about that this benefit on the injury leave. What he didn't say is that workers' comp has a very long history of denying claims right up front. And they have a look into your entire medical record, and if they can find anything in there that indicates the injury happened before or that there's some other reason for the injury, they're going to deny it. If it's an injury related to an illness or injury that's covered under Chapter 607, 9 times out of 10, they're going to deny it. So if you've got a brand new employee, somebody's been on the last 2 years, maybe has 3 weeks vacation built up, 3 weeks sick leave, when that's gone, he's going to not receive any money. And if the claim has been denied, he's not going to receive any temporary income benefits until you go through the whole process of a BRC, a CCH, and any appeals that happen after that to the ALJ or district court. So this is a stopgap to keep those guys to be able to feed their families while all those appeals are going on. If they ultimately win the appeal, they're going to get all their vacation and sick leave back, and the insurance company is going to pay temporary income benefits. Another thing is that even though in the past we have passed legislation to expedite claims and appeals of claims for first responders, the process can last up to 2 years. There's a provision in the law about maximum medical improvement, MMI. There is no requirement that a physician issue an MMI rating for up to 2 years. So these officers don't have the ability to make a decision whether to take pension benefits or disability pension benefits until that MMI rating is issued. And if the doctors do not feel that they have completed all of their treatment, then they're not going to issue the MMI rating. That's what my comment on the injury leave. I do want to make one other comment about the heart attack provision. In 2019, we worked diligently with Senator Eddie Lucio and Representative John Ray to add peace officers to the heart attack presumption. The problem is we didn't fully understand some of the issues with that presumption in that it only applied to on-duty incidents. As we've seen, because of the adrenaline dump that occurs when you fight somebody or you get into a high-speed pursuit or you're involved in some other enforcement action as a peace officer, that adrenaline dump takes place, but the heart attack may not happen for 4, 5, 6 hours after. And we've had officers go home, go to sleep, and not wake up the next morning. So there needs to be some time period that allows that calming down period to occur to see whether the heart attack is going to occur because of the incident, the precipitating incident that happened on duty. And so I appreciate Representative Patterson tackling that problem, and hopefully you all are going to give this bill your due consideration and move it forward. I'd be happy to answer any questions.
Members, any questions? Thank you. Thank you. Members, we have Alan Craddock, Deputy Commissioner for Hearings with the Texas Department of Insurance, Workers' Compensation Division, if anyone has any questions. Okay. All right. Well, is there anyone else who wishes to testify on, for, or against House Bill 471? If not, the chair recognizes Representative Patterson to close on HB 471.
Thank you, Mr. Chairman and members. I'm glad that we had a few people go after TML because I was pretty fired up back there. I've sat on this committee for 2 previous sessions, and I've seen TML wait until the very last moment to throw up a red flag about a bill and not work with the bill author, me and others, and not work with the bill author to actually come to a solution. We got an email from TML on Thursday of last week. Having worked on this issue for years, Thursday of last week, they sent us that they don't like Section 1. They have no recommended language to address it or anything, just we don't like your bill. That happens session after session on this committee because the bottom line is they value dollars over the lives and the health and safety of our first responders in our communities. It is unconscionable to me that you would say that small communities cannot fund a firefighter that has been injured in the line of duty, going into that building, having the building fall down on them, break their back. They're on their own because a small community can't take for it. If that's the case, then don't hire a firefighter or a police officer. It's ridiculous. And I'm fired up about it, and I'm not as fired up as I was 5 minutes ago before the other folks started. But it's ridiculous to me that we cannot come together on language and get everybody in the room. The risk pool, TML risk pool, was a part of the discussion, but TML didn't. They just sit here session after session and oppose our first responders, and I'm sick of it. But I'll take any questions that y'all have at this time.
Members, any questions for Representative Patterson? Representative Frazier?
Yeah, I just want to make a comment. I just want to thank you for taking on this challenge. It's in our circle of my 27 plus years, this has been a ginormous problem. And it's a problem every time somebody gets hurt. There's 78,000 police officers in the state of Texas, one liaison. There's you divide that in half of the amount of firefighters are in the state of Texas, there's one liaison. And so all of them have to go through the same nonsense every single time they get injured, but you're asking them to be injured for the work they do. And when they try to get fixed, it's the biggest problem. And you're seeing it now, and we're trying to fix it. And I appreciate you saying that they finally showed up on Thursday to even reach out to you when I signed onto this bill in January. Yeah. So thank you for taking on the challenge, and I'm there with you.
Thank you.
Thank you. Members? Thank you, Representative.
Thank you, Mr. Chairman.
At this time, the committee substitute to HB 471 is withdrawn, and if there is no objection, the bill will be left pending. Is there objection? The chair hears none, and the bill will be left pending. Chair lays out House Bill 697 relating to the seller's disclosures regarding fuel gas piping in residential real property, and the chair recognizes Representative Holland to explain his bill.
Thank you, Chairman. I am fired up about this bill. We love you, Jared. Thank you, Chairman Longoria and members of the committee. I'm going to tell you a little bit about House Bill 697. I, too, have worked on this bill for now on my fourth session. In most residential home sales, sellers are required under the Texas Property Code to provide information to the buyer of real property about the condition of the property, which benefits both the buyer and the seller. This is called the Seller's Disclosure Notice, which I've just passed out to each of you on the committee. This disclosure form is required by sellers of previously occupied single-family residences and is to be used in conjunction with a contract for the sale of the real property. It contains information required to be disclosed by Section 5.008 of the Texas Property Code regarding material facts and the physical condition of the property, which provides more information for buyers and serves as a risk reduction tool for sellers. This notice is a disclosure of seller's knowledge of the condition of the property as of the date signed by the seller and is not a substitute for any inspections or warranties the purchaser may wish to obtain. It's not a warranty of any kind by the seller or seller's agents. The notice can reduce seller's risk of being sued. If a buyer claims after a closing that he or she didn't know about previous material facts, the sellers can point to the section of the notice where they indicated the material fact, assuming the sellers filled out the notice honestly and correctly. The current practice is that the seller has the option to check the box that most closely matches with their knowledge of the material facts, yes, no, or unknown, if they have no knowledge. The notice requires the seller to provide their awareness of all material items in the home that are in not working condition, have known defects, or that are in need of repair. House Bill 697 adds the type of fuel gas piping, if applicable, that is presently installed inside of a property to the seller's disclosure notice form. A box checked on the notice will notify the buyer of a property as to the type of fuel gas piping in the property. Black iron pipe, copper, or corrugated stainless steel tubing, known by its acronym as CSST. Both as an advocate for fuel gas piping awareness and two, as a 17-year practicing real estate broker, I believe that the bill is a prudent change to the seller's disclosure notice in Texas and is a material fact regarding the physical condition of real property, which is the purpose and reason for disclosure by sellers to buyers. I do have invited witnesses who have registered to testify. Becky Teal, a personal family friend and constituent who I've worked with for the past 7 years on this piece of legislation and now for a fourth session in what we hope to all be the final version of the bill, and it seems to be acceptable to all stakeholders on the issue. I will note the reason for this bill not passing last session was, like many of you who were here with me last session, we had that one night at the end of session where the other side that we keep talking about, they got about 1,000 of our bills or something one day and passed about 300 of them. So this bill got caught up in that. Chairman Hughes, Senator Hughes, is my companion on this. He is carrying it again, and we are very thankful for the early opportunity, Chairman Longoria, to have this hearing this session. With that, I'll answer any questions and reserve my right to close.
Representative Lambert.
Thank you, Mr. Chairman. Thank you, Representative Holland, and I was one of those that heard this bill in committee last session and appreciate you bringing it back again. Just, thanks for handing this out, because really my question was about what other examples are there where there are multiple choices on a seller's disclosure?
Yes.
I think you've given us
I did. Well, thank you for asking. So the reason that I handed this out to you is because there are other similar material facts on seller's disclosure to interested buyers. They are and you can see as you look through here, there's a lot of boxes, yes, no's, and unknowns, and there's a lot of electric, gas, or number of units, but ovens, stoves, microwaves, fire detection equipment, smoke detectors, carbon monoxide detectors, central heating and air systems, electric or gas water heaters, gas fixtures, gas or wood-burning fireplaces. There are numerous instances on a seller's disclosure where you're required to tell simply the type of product that exists in the home, a material fact.
So I assume that basically with a house that was built in the 50s, maybe there's going to be a lot of unknowns, basically, that transcends all the multiple times that property
Sure.
is sold.
Most likely a house built in the 50s is going to have black iron pipe. A house that may have been built sometime in between could have copper or CSST. A lot of homes built after 2000 will have the CSST. The way that you would know this, which is a common question that I'll just bring up, most buyers have an inspection done on the property. The inspectors in the state of Texas are required to tell you about the presence of corrugated stainless steel tubing, or you could just go up in your attic and look. And you could also say, I don't know, unknown. So there's an out. If you don't know and you haven't had an inspection, we think that if the buyers are required to know by their inspector, the seller should be required to also back that up.
So does this form get filled out before the inspection, or is it usually post-inspection?
This film should be filled out prior to the home being listed and provided in the supplemental documentation on the multiple listing service so that people can read this before they have it. As a broker, I'll often have people say, I noticed on the seller's disclosure, or do you have a seller's disclosure? I didn't notice one up there. And sometimes it's a timing issue, but this should be filled out prior to a home even being listed.
Thank you.
Members, any questions for Chairman Holland? Now we'll proceed to public testimony. Thank you.
Thank you.
The chair calls Becky Teal. And we show you registered as Becky Teal on behalf of yourself, and you'll be testifying for the bill. Is that correct?
Correct. It might not be a good idea. I'm Becky Teal from Heath, Texas, representing myself, and I'm in favor of this bill. Thank you, sir, for sitting next to me. Seller's disclosure statement exchange in a transaction is an outline of awareness, knowledge, and disclosure. Corrugated stainless steel tubing is CSST, is the product of concern for me and the focus of this bill. HB 697 has no negative impact for stakeholders, and the additional line in the seller's disclosure is not listed under the warnings or hazards or a red flag of stigma but merely sits among the boxes of information that should be checked. The proposed language, which Representative Holland has said, line 25 reads that gas is present. It identifies what kind of gas, propane or natural. It identifies the conduit in which it's conveyed as black iron pipe or flexible tubing. The handouts you've been given in my yellow folder are specific to one product, and it's the CSST. And there's been public safety resolutions from nationally recognized organizations stating their independent findings and concerns for the product. The latest reports are from TREC that Representative Holland mentioned, and then we have additional testing and documentation from Integrity Forensics and Engineering. So we also have resolutions from the Texas Fire Marshal Association and the position paper from International Association of Fire Chiefs, LPI, Lightning Protection Institute, an incident report from Texas Department of Insurance. So I am here to ask you to add 12 words to this seller's disclosure. 12 words, not much. The gas is present, that it's propane or natural, that it's black iron pipe or flexible piping. Why I care? I lost a kid, a son. And I've included a letter from him written by me in your packet, and with his picture, just so that you can identify emotion and product safety and facts. So I've studied all of your bios, and I love your statements of making a difference, and I'm here to do that today. So ask me questions. Tell me what you need to know. I have products here that are new and have been burned, and I'm here for you.
Representative Lambert.
Thank you, Mr. Chairman. Becky, thank you for coming back again this session. And again, I'll say the same thing I said last time. We're sorry that you've had to experience this in a very personal way. So I just wanted to say thank you for coming back and for your testimony today. Thank you.
Representative Frazier.
Thank you, Chairman. Still, I'd like to just say thank you for being here. I know how this is very tough for you to be up here to give that testimony. But thank you for the kind words, and thank you for what you're doing.
Thank you.
Members, thank you very much for coming, Becky. We appreciate your testimony. Chair now calls Ariana Kistner. And we show you registered as Ariana Kistner on behalf of yourself, and you will be testifying for the bill. Is that correct?
Yes, sir. Thank you. Thank you for having me here today. For over 25 years in the state of Texas, I've served as a fire marshal in various cities across North Texas. During that time, I've had the unfortunate opportunity to participate in hundreds of fire investigations, many of which involved CSST corrugated stainless steel tubing. But most importantly for the testimony today is that many of these home fires could have been prevented with some simple steps by the homeowners had they just been aware of the risk in their homes. Especially when it comes to CSST, there are some very simple steps a homeowner can take to help mitigate the risk associated with the product. Just simply as bonding and grounding the material in their home, just being careful when they put their Christmas tree into their attic. So many of us just throw stuff up into the attic. If you have this corrugated stainless steel tubing, and you happen to hit it and push it up against another metal object, it has the potential to ground out with lightning in the area, which is why we see an increase of home fires with CSST present in the homes. And I think if homeowners just knew to take a little bit more cautious when they're up there in their attics, or some of the steps they can take to prevent it in the first place, it would go far. I think this bill serves as an incredible opportunity to educate homeowners on a potential risk in their home. Thank you for your time.
Thank you. Members, any questions? Thank you. Is there anyone else who wishes to testify? Oh, members, we have Tony Slagle, Deputy Executive Director with the Texas Real Estate Commission, here to answer any questions. All right, well, thank you. Is there anyone else who wishes to testify on, for, or against House Bill 697? If not, the chair recognizes Chairman Holland to close on HB 697.
Thank you very much, Chairman and members. In closing, I would say that I echo Becky's remarks that we have an opportunity to do something as legislators that makes a difference, and that's what I think we're all here for. I will also reiterate, the purpose of this bill is to provide disclosure of material facts. It's not to create a negative stigma on any product or products. As a matter of personal note, my wife and I, when we bought our house in 2016, we bought a house that did have CSSD present. We took the steps needed to have it bonded and grounded as it is recommended, and those are the things that sellers and buyers need to know. There's a very inexpensive fix, but if you don't know that it needs to be fixed, there can be risks, just like there can be with anything else, and that's why we point these out on a seller's disclosure so that a buyer's informed and the seller is disclosing everything they know about their property. And so that we don't have a situation where, another unfortunate situation where mothers have to travel 8 years in a row to try to get something done, so that it doesn't happen to another family. Brennan Teal was a close friend of mine. We lost him in 2012, and it's 11 years later, and I think we may be able to do something about this session. So with that, I close, and thank you.
Thank you, Chairman. Members, any questions? Thank you. If there's no objection, the bill will be left pending. Is there objection? Chair hears none, and the bill is left pending. The chair now lays out HB 4 relating to the regulation of the collection, use, processing, and treatment of consumers' personal data by certain business entities, imposing a civil penalty. The chair recognizes Representative Leone to explain the bill.
Chairman Longoria.
Representative Lambert offers a committee substitute on HB 4.
Yes, thank you. Good morning, members. Thank you for the opportunity to address the committee. On October 15th, 1999, 20-year-old Amy Boyer was leaving her office for the day. As soon as she opened up her car door, a man waiting for her came out from behind a corner and shot her multiple times. Unbeknownst to her, the man was her stalker, who just 48 hours earlier was able to purchase Amy's social security number, workplace address, and the phone numbers to every one of her relatives online for just $45. That tragedy sparked the first attempt at a national data privacy law, the Amy Boyer Law, which would have put in place basic protections for the handling of sensitive personal data. Thanks to intense lobbying pressure, Congress has failed to pass not just the Amy Boyer Law, but also every single attempt at a national data privacy law in the last 24 years. Today, the company that sold the data that killed Amy Boyer is still selling personal data online. The only difference is that the price is now $49, not just $45. Members, we cannot continue to wait on Washington, D.C. to protect Texas residents. When a company makes the decision to sell our personal data, it doesn't just open us up to targeted advertising. It takes away our control over the information that is most personal to us. As we approach the 25th anniversary of Amy Boyer's murder, Texans must no longer suffer the consequences of inaction. Our personal data belongs to us. It is time that we empower Texans with the rights necessary to take back control over their data. HB 4, otherwise known as the Texas Data Protection and Security Act, will do just that. The bill provides every Texas consumer with 5 rights to control their personal data. 1, the right to know when personal data is being collected. 2, the right to access personal data and receive that data in readable format. 3, the right to correct and delete personal data. 4, the right to opt out of the collection and sale of this data. And 5, the right to not face retaliation or discrimination for exercising your rights. While Texas is not the first state to pass a comprehensive data privacy law, HB 4 builds on the principles established by California, Virginia, and Utah to ensure our legislation keeps up with the rapid pace of technological innovation. By doing so, the Texas Data Protection and Security Act before you will be the strongest data privacy and protection law in the country, a safeguard for our citizens, and a model for the nation. The bill creates strong requirements for how a consumer can exercise their rights by contacting the company selling their data. HB 4 requires these companies to have at least 2 secure ways that a consumer can exercise their rights. These methods generally take the form of online portals, email addresses, or phone numbers. They must also post these methods in a privacy notice that is easily accessible and easy to read. The bill also states that a website must warn consumers if the website engages in the sale of sensitive personal data or biometric personal data. The bill also departs from other states in determining who the bill applies to. Most other states use a threshold of users or revenue derived from the sale of personal data, but HB 4 simplifies this. The bill applies to any company that, 1, has products or services consumed by Texas residents, 2, engages in the sale or processing of personal data, and 3, is not a small business. This provides a clear scope and ensures small businesses aren't overburdened with compliance requirements. Small businesses would still be required to receive consent from a consumer before selling sensitive data. HB 4 includes the most expansive definition of the sale of personal data. Now, in these other laws in other states, the sale of personal data is defined as a quid pro quo exchange of money for data. But in reality, online transfers of data are often complex and involve many different parties and incentive structures. The definition in HB 4 ensures that any transfer of personal data to a third party for any monetary gain is considered a sale of data. Now, you will likely hear from some folks today who do not like that definition, so I would encourage you to ask them what personal data they transfer to a third party that they do not think should be considered a sale. However, as the ad tech field advances, even the idea of personal data can become moot. Personal data is generally considered to be data that is linkable to an individual. Yet many forms of identification on the internet are not necessarily linkable to an individual. For example, an IP address, a username, or even home address may not directly link back to an individual. However, if an advertiser layers all three of those pieces of data together, it is pretty clear that it links to a specific person. Now, what we refer to that as is pseudonymous data and is often used to get around data privacy laws, and we've seen that in other laws. But HB 4 states that if a company is layering pseudonymous data to link to an individual, it is considered personal data, and consumers have a right to control that data. Finally, the Attorney General has the sole authority over the enforcement of this bill. The Attorney General's office may issue a civil investigative demand at the request of a consumer, or if they have a reasonable cause to believe any person has engaged in, is engaging in, or is about to engage in any violation of this bill. Civil penalties are $7,500 per violation, and the Attorney General's office must provide companies with a 30-day cure period. There is no private right of action provided under this bill. Now, you'll no doubt notice that there are many who will be testifying in favor of this bill. I've been working on this bill with stakeholders for over 6 years. My staff and I have kept a list of nearly 200 stakeholders whom we've solicited feedback from. Together, we've been able to reach a compromise on a bill that goes above and beyond on consumer rights and minimizes the compliance costs for Texas businesses. You'll find that 90% of this bill codifies practices that responsible companies are already doing, while the other 10% are practices they should be doing. It is that 10% that makes HB 4 the strongest data privacy law in the country. Members, I thank you all for your time and consideration and look forward to working with all of you to ensure the Texas Data Privacy and Security Act becomes the standard bearer for consumer data privacy across the country. More than happy to answer any questions. Reserve the right to close, Mr. Chairman.
Thank you, Chairman Capriglione. Representative Lambert.
Thank you, Mr. Chairman. Thank you, Chairman Capriglione, for bringing this bill. I know we're going to go a lot of different directions, but I just want to start off by asking you, can you give me some idea kind of what the bill encapsulizes in terms of minors and tools that parents can use to protect minors in terms of privacy and so forth?
Sure. And one of the things to note is there are some federal laws, for instance, like HIPAA, privacy laws that help with health providers and health data. We have some that specifically focus on banks. The federal government has a bill, has a law, COPA, that primarily is focused on children aged 13 and under. Now, under our bill, a parent or a guardian may exercise their rights on behalf of a child 13 years or younger. So all of those rights that I talked about in this bill, parent or guardian can exercise on behalf of a child 13 or older. Now, additionally, what we've done in this bill is that the data of a child is considered sensitive data, which provides it additional protections in the legislation. And also, children 13 to 18 can exercise any of the rights that are in the bill by themselves as well.
Thank you.
Thank you.
Representative Hinojosa.
Thank you, Chairman. First, Representative, I want to congratulate you on putting together a very complex piece of legislation and for delivering it to the members of this committee in a way that someone like myself who knows very little about this topic can understand. So I want to thank you.
Thank you.
For doing that for us. I have a few questions. I'm going to start with maybe the hardest question first. So, and I'm referring to the original version just because I don't know where to find this in the committee substitute. But under subchapter D, enforcement.
Yep.
So the Attorney General has the sole enforcement over this bill, over this legislation. I'm not going to ask you a question about that. I just want to state that.
Yes, that is correct.
But there's a section 541.152 that says that he can engage in a civil investigative demand if he has reasonable cause to believe that a person has engaged in, is engaging in, or is about to engage in a violation. And it's that language of is about to engage in a violation that I want to better understand because I'm getting like a Minority Report vibe from that.
Sure, and that's a good point. And what I will say is that most other laws that have passed in other states have provided not only the Attorney General, but they've given the Attorney General's office regulatory authority as well, which this is not. Some of them also have, private right of action. Ours does not. That being said, what the bill requires is that these companies have what's called the data assessment report, right? It's a report that describes their processes, their controls, their procedures inside of the company, how they're governing and issues that they see regarding to how they're handling private information. There's quite a lot to it. And so the language you're referring to specifically would allow the Attorney General access to that report, right? So that's the action about the before something happens would be for the report. That all being said, it's duly noted, and I will talk to stakeholders, including yourself and others, and I think it's reasonable to maybe remove the section about to.
Okay, well, let's continue
Yeah,
to talk about that. I appreciate you
100%.
considering that. There's a section of this bill that says it does not apply to the state or other governmental entities.
Yep.
It doesn't say it doesn't apply to a private entity the state contracts with, and so I am assuming and hoping that it would still apply to someone in that, an entity in that situation.
Yeah, so last session, we passed significant legislation to address government and private personal information. So a private company, regardless of whether they contract with the government or not, is subject to all the same definitions and rules that are in here. Now, the data between a private contractor and the government is a little bit more complicated, right? Because we pass legislation so the government oftentimes cannot give certain data to anyone. Also, often the data that the government has would be considered publicly available information, obviously anything that's subject to open records requests, for instance. And so that's why there's kind of this delineation between the government and these private companies. But the short answer to your question is a company is subject to all the rules here, regardless of whether they have a contract with the government or not. It's just the data depends what it is.
Okay, thank you.
Members, any questions? Chairman, I think there's reference about the Virginia data. I think it's the Consumer Data Protection Act, and this kind of builds upon that. Can you kind of explain what the differences of your House Bill 4 are in comparison to that?
Yeah, so there's several differences. There are a few states that have gone ahead and passed laws. Virginia's is probably one of the models that was put in place about a year and a half ago or so. What we did is we looked at that as our starting point, but felt that there were opportunities to improve upon the law. Maybe the most significant is the pseudonymous data piece. Pseudonymous data, again, is there's personal information, and then there's data that's de-identified. You can't get back to who that person was. Oftentimes, though, for the sake of simplifying, a key, right, that will translate between or de-identified data and a way to identify that. The Virginia bill let both of those go. We did not. We wanted to provide protections, even if on legislation, on data that could be re-identified. Second thing is we focused on the sale of data and what that really means. You think those three words they're simple to say, but they're probably taking 90% of the effort, which is what does sale mean and what does data mean? What we were able to do in this bill was to broaden the scope of what sale means. It's not just I'll give you cash and get that back. Oftentimes there's complicated agreements, and we wanted to include that in this legislation. Another big piece is who this is applicable to. So in Virginia's bill, they basically said, okay, if you have so many customers or if you get this much of your revenue from sale of data, then it applies to you. And honestly, my two issues with that is you don't really know how many customers somebody has, right? A business has. So it's not easy to go and say, hey, should I look into what you're doing? So someone complains and the rule is they have 100,000 customers. There's no way to know that, right? So what we wanted to do is say, let's go and use very specific information, revenues. That's stuff that you go to a comptroller's office, you could go and get from the financials, you apply or you don't apply. Businesses know whether they're a small business under the SBA definition or if they're not. And listen, if you look at how some of these other bills in other states were done, they'll say, okay, 50% of your revenues come from sale of personal data. Unless you hit that number, this doesn't apply to you. Well, there's very few companies that make half of all their revenue from the sale of personal data. What we wanted to say is, listen, if you're a company that can and should, and there's an expectation, right? So there's an expectation if you go to a large size companies and they're collecting your name, they're collecting your social security, that they're going to protect it, that they're not going to sell it, that they're going to take care in who they share that information with. And those are three of the largest changes between ours and Virginia's.
Thank you. Members, any questions for Chairman Capriglione? Well, thank you. If there are no
Thank you, Mr.
questions,
Chairman.
we'll proceed to public testimony.
Thank you.
Chair calls David Dunmoyer. And we show you registered as David Dunmoyer on behalf of Campaign Director for Texas Public Policy Foundation, and you will be testifying for the bill. Is that correct?
Yes, sir. Good morning, Chair, members. My name is David Dunmoyer, Campaign Director for Better Tech for Tomorrow with the Texas Public Policy Foundation. First, thank you for hearing this bill today and the opportunity to testify in support. Everything we do online today translates into data that is being tracked, analyzed, packaged, and ultimately transferred. And the types of personal information collected ranges from what we consider to be the more obvious, things like social security numbers, our likes and dislikes, where kids go to school, to the even more dystopian now, the routes we take for our daily activities, how long we spend at our destination, and even the details of our most private, intimate settings, which would be our homes. But because Texans currently lack control over their personal information, there are scores of harms happening daily, even if we don't always see them. First, absent consumer control over personal information, data can be sold, as Representative Capriglione laid out, to nefarious actors. And there are far too many stories, personal stories, of this information being sold to criminals that use private information of their victims to hunt them down, harass them, and even kill. And second, the opacity of the data collection and storage regime means that personal information is not always stored securely. And as senior Facebook engineer Eugene Zarashaw put it when asked the simple question of where personal information is stored, he responded with, quote, I don't believe there's a single person exists who could answer that question. And as more consumer data is collected, the magnitude of looming data breaches becomes cataclysmic. So as we know, the status quo is simply unacceptable and puts Texans at dire risk every day, but insert House Bill 4, which provides a comprehensive solution to these myriad challenges the state of Texas is facing. At a high level, it does three major things that is important for all of Texans to be able to combat this current status quo. First, it would give Texas consumers digital rights, including the rights to know what information is being collected and obtain a copy, to correct and delete certain information, and the right to opt out of certain data processing. Second, and importantly, House Bill 4 also establishes what are known as data minimization standards, as well as data protection requirements, hitting at the core of a lot of these issues or these risks associated with data breaches. And finally, by enforcing this bill through the Office of the Attorney General, Texans could exercise their digital rights with recourse where appropriate. As a matter of personal safety, privacy, and civil liberties, it is crucial that we put Texans in the driver's seat to exercise control over their personal information. Thank you, and I welcome any and all questions.
Thank you, members. Any questions? Thank you. The chair now calls Stephen Scurlock. And we show you registered as Stephen Scurlock on behalf of the Independent Bankers Association of Texas, testifying for the bill. Is that correct?
Correct, Mr. Chairman. Thank you. And committee members, good to see you as well. I am Steve Scurlock. I'm with Independent Bankers Association of Texas. At the outset, I do want to thank Chairman Capriglione and his staff for the remarkable persistence in addressing the issue of data privacy and security over the years. You may have noticed that financial institutions are among those entities exempted from the requirements of HB 4. This very broad category of businesses has been subject to stringent and frequently updated rules since the passage of Gramm-Leach-Bliley in 1999. The world has definitely changed a little bit since then. It is being kept up with by a group for the financial institutions called the FFIEC, Federal Financial Institutions Examination Council, which updates those rules very frequently. The FTC, oddly enough, I have FDIC on my mind after the occurrences of this weekend. My apologies for that. The FTC is also engaged for non-financial entities that fall under this as well. This statute does not only provides for customer privacy protection and plain language disclosure of information sharing arrangements with the ability for the consumers to opt out, but also to the safeguarding and security of personal information. As I have said frequently before this committee, if everyone handling PII or sensitive consumer information was subject to the same Gramm-Leach-Bliley standards, we would be absolutely delighted. As was mentioned by the last witness, our community bankers continue to be concerned with the epidemic, if you will, of data breaches and the impact not only on us but on our customers as well. As you know, our banks suffer the brunt of the expense and headaches subsequent to a data breach. When a breach occurs at any entity, banks end up taking the vast majority of the losses. When a breach occurs at a bank, banks end up taking the vast majority of those losses. While not immune from those breaches, I would submit that banks take extraordinary steps to prevent the compromise of customer data and do take the responsibility when it occurs. The safeguarding of sensitive consumer data and requirements under the data protection assessments in HB 4 will hopefully help mitigate this ongoing threat to our privacy and personal financial information. As mentioned also before, this is a very complex piece of legislation with a number of moving parts. And I am absolutely sensitive to the concerns expressed regarding compliance with multiple state statutes on this issue, but once again will urge those who are concerned with this dynamic to come to the table in good faith to get a standardized bill passed in D.C. that will mitigate that particular issue. We've supported numerous proposals to address this issue over the past 10 or so years at both the state and federal levels. Again, we appreciate the efforts of this committee, Representative Capriglione and his staff, along with many others who have worked on this. We look forward to continuing to work with the committee. I would be happy to attempt to address any questions that you might have.
Members, any questions? Thank you.
Thank you very much.
Chair now calls Brianna Gortley. And we show you registered as Brianna Gortley on behalf of Texas Appleseed, and you'll be testifying for the bill. Is that correct?
Yes, can everyone hear me? Awesome. Chairman Longoria, Vice Chair, committee members, thank you so much for this opportunity to provide testimony on House Bill 4. It has been quite a journey to get here, but we're very pleased to support the representative's bill. I want to start by providing just a bit of background on who I am. Anytime we're in this policy space and we're looking at legislation, I come at it from a victim advocate perspective ranging from paying auto title lending all the way to data privacy. I'm very specific in what I look for, always the positives, but mainly the concerns and the gaps. And when it comes to survivors of domestic violence, victims of human trafficking, vulnerable youth, and older adults in the data privacy space, the gaps are immense. There are no protections. And so when House Bill 4 was introduced into the legislature, we saw an opportunity to protect a really vulnerable group, many vulnerable groups who, one, aren't even familiar with how data privacy affects their lives and can impact their safety. And I'm so thankful that the representative opened with Amy Boyer's story, because that's a story I share very loudly to show how a lack of protections can end someone's life. And so while data privacy protections usually are not that drastic safety and physically, they absolutely can be drastic financially. And so in the written testimony, I provide several different examples of how a lack of protection, specifically with data, can impact people's financial stability. I mentioned data brokers and how this very unregulated industry does leave a very wide gap in the types of data that's shared and collected and sold. So really, I wanted to sit here and say that amongst all of the positives of the bill, we're really thankful that so many different stakeholders have come together, because I am very mindful and aware of how difficult this conversation has been. But at the end of the day, my sole perspective is always about how this will support survivors of domestic violence. And so there are a lot of strengths in the bill. I touch on a lot. There's one small gap I'd also like to talk about, although we are in support of the bill. And so when we're thinking about survivors and we're thinking about their safety, urgency is always a key factor. And so whenever a consumer submits whatever request it may be to opt in, to delete, to access, a controller is given up to 45 days to grant that request and can apply for an extension for another 45 days. So let's say up to 90 days. For a survivor of domestic violence who is actively fleeing a dangerous situation, 45 days is too many. And so we know it's up to the business's discretion. They could do it the next day. They can delete a consumer's data the next day, absolutely. But they're given a lot of leeway, and that's what's really concerning to us. And so we spoke to the representative's office and, wanted to offer a type of solution, just one small thing that does not, require the businesses to do any additional work, but that does give consumers a pathway whenever they do go to submit a request to say, hey, my personal safety or my security is in jeopardy. Can you please consider that as you move forward with processing my request? Again, that is one small concern of ours, but overall, we're so grateful that so many powerful voices have come together to protect all Texans. And I'm happy to answer any questions or try to that you may have. Thank you.
Members, any questions? Thank you.
Thanks.
Chair now calls Steve Perkins. And we show you registered as Steve Perkins on behalf of yourself, and you will be testifying against the bill. Is that correct?
Yes, thank you. Chairman Longoria and committee members, thank you for the opportunity to testify today. Texas needs a privacy law. To me, the main question is, does this bill provide the privacy protection for Texans, the best privacy protection for Texans? At this point, I'd have to say the answer is really no. I'd encourage you to vote against HB4 unless it is improved. For 40 years, I've worked in marketing research and analyzing and teaching how to do data analysis for Burke Marketing Research in Dallas, and was associate dean for graduate programs at the School of Management at UT Dallas. So I've been living with data for a long time. Today, I'm just representing myself. Both of my parents grew up on farms in West Texas. And you may wonder, what in the world does this have to do with HB4? But it makes me think of an old farm saying, it's sort of like trying to close the barn door after the horse is out. In other words, trying to stop something bad from happening after it has already happened. This privacy bill tries to close the barn door after the horse is already out. It claims that I can stop a company from selling my data, but in fact, companies can sell, share, and transfer my data long before I can stop them. Let's walk through a short example and see how this works. Say I go to a website and I buy some clothes. The company collects my personal data. We complete the transaction. That interaction with a data collector, controller between me and them is fine. That's above board. I understand that. What happens next, though, is neither above board nor reasonable. The controller can sell my data to brokers, share my data with marketing firms to be used for targeted advertising, transfer my data to other internet players. The assumption is that my data is fair game. Sure, in the bill, it says that websites must provide a privacy policy that explains what they collect and how they're going to use it. The current Facebook privacy policy is about 16,000 words long, for instance. Under the provisions of this bill, somewhere in that privacy notice, it will say that I can send in a request to opt out of the sale of my personal data. As we just heard, though, the controller has 90 days to comply with that request. And I must send the request to every separate website. So if you deal with 100 websites a month, you would have to send this request to each one. By the time the controller complies with my request, my data has been transferred, sold, shared with data brokers and other internet companies that I have no relationship with. Why should they have my data? Axiom is a data broker. They have over 11,000 pieces of data on you. They collect data from websites by using cookies, for example. They can sell your data to other marketing companies. You didn't really give them permission to buy or sell your data. And will they stop using your data just because you turned in an opt-out request? Call me skeptical. The horse is out of the barn. Your data is long gone. They have no real incentive to help control that data. So how can we improve HB4? Let me make two suggestions. First, companies should honor global privacy controls. That is a browser setting that notifies companies of your privacy preferences by sending out a signal to each website you visit. Browsers such as Mozilla Firefox already offers global privacy controls. This bill would just need to require that the companies act on that signal. My global privacy control could be set so that I never allow sharing or selling of my personal data to other companies unless I specifically allow it. Second, the state should set up what is essentially a do not call list for the internet. Maintain a list of people who have requested a universal opt-out. Companies must check that list before selling, transferring, sharing my data. Unfortunately, HB4 does not really promote either of those right now. Instead, it really places the burden on the individual to protect their own data and opt out from every single website. HB4 has been termed Virginia Plus, which is true, but you should also know that it started its life in 2019 as the Washington State Privacy Act. It's been introduced in the Washington legislature 3 times, and it's failed 3 times. It's failed because of several weaknesses, including the ones I mentioned, and I think we can do better than this. HB4 should be built on the assumption that companies do not have the right to sell, transfer, or share my data unless I give them permission. Include the idea of universal opt-out mechanisms. That would be privacy, and I think that's what Texans deserve. I recommend that you vote against this bill unless it's revised. Thank you.
Thank you, members. Any questions? Representative Lambert.
Thank you, Mr. Chairman. I'm trying to use your analogy about how do we get the horses back in the barn, but So in your opinion, this is not a good first step? Many times, these comprehensive bills and the start to reform sometimes takes a good first step, but there's always subsequent policies that sometimes need to be tweaked, refined. So you're not of the opinion this is even a good first step?
Well, and I know Representative Capriglione and have worked on data privacy since 2018. And so I know he's made tremendous efforts, and I give him a lot of credit for pushing this ahead. I would have given up after I know he's been through this at least 3 times before. So I think it is a good first step. I would really like to see that strengthened as far as don't let the companies have as much data in the first place is really what I'm saying. Just keep that data secure with the consumer, and you don't necessarily have to let the companies have the data that they can then sell or transfer or share.
But you would agree that because the federal government hasn't made any real effort to try to do something that would affect all of us, that states do need to step up and do something, so.
Yeah, states are stuck with this because the federal government has not been able to move ahead. Thank you.
Members, any questions?
I got one.
Representative Frazier.
Thank you, Chairman. Hey, just curious, how often, or let me ask you this, how much have you worked with the author in his office?
We've talked a few times, and I've contributed some of the comments that he mentioned earlier this year. Yeah.
So it sounds to me he's put a lot of time into this.
Oh, yeah.
And you've talked a few times?
Over the years and a couple of times recently, yeah.
Yeah, I think you'd spend more time with him. Just my opinion. If he's working on this for like 7 years.
Yeah.
So, anyway.
Members? Well, thank you.
Yep.
Chair now calls Jordan Crenshaw. And we show you registered as Jordan Crenshaw, Vice President of U.S. Chamber of Commerce, and you will be testifying neutral to the bill. Is that correct?
That's correct. Chair Longoria, Vice Chair Vasut, members of the committee, thank you for the opportunity to speak today about HB 4, and we also thank Representative Capriglione's leadership to protect privacy as well. The data-driven economy is helping small businesses compete and survive through tough economic times. Just to show that, the U.S. Chamber released a report last year that showed the impact of technology platforms for small business. 80% of small businesses nationwide informed us that the use of tech platforms like payment apps, digital advertising, delivery apps have actually helped them compete with larger companies. 83% of Texas small businesses say that without access to these digital tools, their business would struggle to survive. 79% of Texas small businesses actually said that heavy-handed limitations on data would harm their operations. In fact, I had a chance to chat with the owner of an independent taco shop in Houston just last year, and he told me that digital advertising helped him save money during a time of economic uncertainty and actually helped him identify consumers that were more likely to buy his tacos. They're actually really good, too. But how do we ensure that consumer privacy is protected, that small business can compete? Well, the simple answer is a preemptive national privacy law. But until Congress can pass a bill that works for all Americans, states like Texas can lead and harmonize their own privacy laws with other reasonable data protection frameworks already in place. HB 4, as you already know, is very similar to other reasonable bipartisan privacy laws that have things like the right to correct, delete, opt out, and access data. But I want to talk about some of my observations about what other states are doing in 3 key areas, and that's enforcement, the definition of sale, and also compliance periods. When it comes to enforcement, 5 states have passed comprehensive privacy legislation, and none have passed a private right of action. Let me repeat that. None have passed one. In fact, the Washington state bill that was just referenced failed to pass in large part because of attempts to insert a private right of action into otherwise reasonable compromise legislation. State AGs are best positioned to be the enforcers of privacy legislation. Second, with regard to the definition of sale, it's important we get that definition right because overly broad definitions could potentially chill societally beneficial uses of data. HB 4, along with other states adopting bills similar to Virginia, Colorado, and Utah, give consumers the right to opt out of data sales. The concern, though, is that if the definition is too broad, consumers may inadvertently opt out of data sharing that has a societally beneficial or consumer-friendly purpose like public safety or financial inclusion. Both Republican and Democrat legislatures in Utah and Virginia, respectively, have generally developed consensus around a definition of sale that means the exchange of personal information or personal data for monetary consideration by the controller to a third party. Finally, with regard to compliance, it's key that businesses, particularly those that do not have robust resources to develop compliance programs like small businesses and others that have not dealt with other state laws, have time to comply. To give some perspective on what other jurisdictions have done, Europe enabled companies 2 years to know how long, what was in a privacy bill. Virginia and Utah give about a year and a half. On the very other side, though, California gave companies a matter of weeks and months between when regulations were adopted and companies had to comply. And in fact, with the latest round of the California privacy law, they're still writing regulations after the bill's in effect. So that's a concern, and that's an area that I think that is not an example that should be modeled. But in conclusion, though, this bill represents a reasonable model that has actually followed many other state models across the country. As Texas continues to be a leader in technology, HB 4 will have an impact on others across the country. We urge you to harmonize privacy laws with other states to give small businesses a more level playing field and continue Texas and the United States innovation leadership. Thank you, and I look forward to your questions.
Thank you, members. Any questions? Thank you, Mr. Crenshaw.
Thank you.
Chair now calls Megan Morrow. And we show you registered as Megan Morrow on behalf of Texas Association of Businesses, and you will be testifying for the bill. Is that correct?
Yes, sir, that is correct. Good morning. My name is Megan Morrow, and I'm testifying in support of HB 4 on behalf of the Texas Association of Business. Thank you, Chairman Longoria and members of this committee for the opportunity to provide comments. First, I want to thank Chairman Capriglione for his work on issues surrounding data privacy and online consumer protections, and for his engagement and consideration of stakeholder feedback throughout the process. These issues are also very important issues for employers and businesses across our state. The Texas Association of Business, TAB, is the state chamber of commerce and the state affiliate of the National Association of Manufacturers. We represent members across every industry sector and size and local chambers. We know from working with our broad membership base that technology issues no longer impact just tech companies. Today, every business depends on information technology to reach and better serve customers, process payroll and HR benefits, accommodate hybrid work, and make things better, faster, and cheaper for our consumers and workers alike. Since comprehensive data privacy legislation was first introduced 3 sessions ago, we have been working with our members to understand how state data privacy legislation would impact them. While most Texas employers prefer a national standard to ensure consistency across all states, we did develop an agreed upon series of principles that we would like to be considered for any proposed state legislation. These principles included ensuring transparency for consumers and giving the consumer clear and balanced rights to control their personal information, preempting other governmental entities, including local governments, from enacting data privacy laws, and of course, strongly opposing the creation of any new private right of legal action against Texas employers. While there are some provisions that employers would like to see more consistent with legislation that has been passed in other states, the current version of HB 4 encompasses these standards that employers agree on, and we thank Chairman Capriglione for welcoming and considering recommendations from TAB and hundreds of other entities and stakeholders. We also hope and request that the data privacy requirements in House Bill 4 are the only such data privacy measures placed on Texas businesses this session. As we've heard, this has been a 3-session effort with significant engagement and complex issue conversations between the Texas legislature and the business community. I really just wanted to reiterate our appreciation of Chairman Capriglione's work with the business community and understanding the implications for employers with data privacy measures. And then again, state that the Texas Association of Business represents businesses of every size and sector, and that technology really impacts every single one. So thank you, Chairman Longoria and members of this committee, and happy to answer any questions.
Members, any questions? Thank you.
Thank you.
Chair now calls Ryan Harkins. And we show you registered as Ryan Harkins on behalf of Microsoft, as Senior Director, and you'll be testifying for the bill. Is that correct?
That is correct, Mr. Chair. Good morning, Mr. Chair and members of the committee. My name is Ryan Harkins, Senior Director of Public Policy with Microsoft, and I'd like to thank you for the opportunity to testify. We thank you for your leadership and thank Representative Capriglione for his leadership in pushing comprehensive privacy legislation in the state of Texas. We support HB 4. We at Microsoft have long taken privacy seriously. In fact, we first started calling for comprehensive privacy legislation in this country in 2005. And the reason was that we have long believed that the public has lost trust in technology. As the amount of information collected about each and every one of us has grown over the years, the public has raised concerns and has lost trust in our industry. And the only way to start to earn some of that trust back is to pass new laws. Laws that will both provide consumers with the rights necessary to control their data, while providing businesses with certainty so that they know what they can and cannot do to innovate responsibly. And HB 4 is an excellent piece of legislation and a great start. There are several components that we think need to be part of any comprehensive privacy law in order to achieve both of those goals, both to provide consumers with the rights to control their data and to provide businesses with clear rules of the road so that they can innovate responsibly. The first is that any privacy law has to contain strong definitions so that it applies to modern online data sets, the kinds of data that is used to track and target consumers on the internet today. And so that means not just data that is identified or stored with your name or your mailing address or even your email address, but data that is identifiable, that could be stored with a cookie ID or an IP address or a device identifier. Those are the sorts of data sets that form targeted advertising profiles and that otherwise are used to track and target consumers online today. And HB 4 does a good job of ensuring that it will cover those kinds of data sets. We have some suggestions for strengthening the definitions further to provide additional clarity that the bill will in fact apply to those data sets. And we look forward to continued conversations with Representative Capriglione about that. Second, any privacy bill has to empower consumers with the rights that are necessary to control their data. Representative Capriglione did a great job of going through those, the right to transparency, to know what companies are doing with your data, the right to access your personal data, the right to correct it, delete it, and significantly, certain consent rights, the right to opt out of certain sensitive processing activities, the collection and use of your data for targeted advertising, or the sale of your personal data. And we think that the definition of sale in this bill is entirely appropriate. The exchange of data for monetary or other valuable consideration. If you were to limit the definition of sale so that it only covered the exchange of data for cash, you would exclude a whole host of transactions on the internet where cash is not in fact exchanged. Data might be traded for other data. It might be traded for advertising space on websites. All of those activities, in our view, ought to be regulated. It also would require consent in order to collect and use sensitive data, things like biometric information, geolocation information, etc. Third, any privacy bill needs to impose affirmative obligations on companies to be responsible stewards of the data that they collect. And HB 4 does a great job of doing that. It would require companies to conduct impact or risk assessments of the data processing activities they are engaging in. It would impose other obligations, data minimization requirements, and data security requirements. So we support the bill. We would urge you to pass HB 4, and I'd be happy to try to answer any questions.
Members, any questions? Well, I would anticipate you probably follow a lot of the legislation that's filed across the country. How do you rank HB4 in comparison to what you've seen in the past?
HB4 would be it is among the strongest bills that we've seen. But I would also say that we think it is a very reasonable piece of legislation. It would provide significant protections to consumers. It is in many ways consistent with laws that we have seen pass in Virginia, Connecticut, and Colorado. And it would be interoperable with the growing list of countries around the world that have passed their own data protection laws, laws like the European Union's General Data Protection Regulation or GDPR and others. So we think it is an excellent piece of legislation.
Thank you. Members, any questions? Thank you. Chair now calls Gregory Porter.
He's got his kids.
Frederick, can you watch him?
Okay.
Stick him in that chair right there.
I thought they were going to test it first.
But didn't you have a son? Okay. They're never too far apart.
So we show you registered as Gregory Porter, co-founder of Texas for Liberty, testifying on behalf of yourself, and you will be testifying against the bill. Is that correct?
Yes, sir. And I didn't just bring them to soften my testimony. My daughter actually suggested that parts of the building could be used as an ice skating rink. It's unfortunate that the bill filing deadline is behind us now. Members of the committee, Chairman Longoria, thank you so much for having me speak. First of all, I just want to say that I'm late to the process here, and I respect that there's been a long-going conversation going on about this just as an advocate, too. So, I'm testifying in opposition to the bill for a couple of reasons, and I understand, I think, first of all, that the nature of the intention of this bill is very good, and I have heard nothing from the people that I respect and the few people that I've had a chance to meet about both the author and many of the co-signers of this bill, and I'm convinced that the intention of that is good, so I just want to make sure that I'm speaking with the utmost respect here. The concern that I have with this bill in general, and just to give a little bit of background, I work for a data security firm out of San Antonio, which was some of the top brass in the Air Force that were responsible for taking down the telecommunications systems in Iraq. So I have a little bit of a history. I worked for Cisco Systems for 6 years, and I'm not an expert and I'm not an attorney. The concern that I have with this bill primarily is twofold. Number one, that large multinational corporations have really become an indirect form of governance at the federal level. And this bill refers to many federal laws that have been largely written by corporations. And that is very concerning to me. Even COPA, and it's not just that COPA refers to a child as 13 years of age, which you can just imagine the orientation of that negotiation would mean that 14, 15, 16, 17-year-olds are going to have to go and grovel with corporations to get them to opt out of a data privacy requirement. It's just not rational. But there's some much bigger issues, just as an example with COPA, not getting into the 7 or 8, I think maybe even 10 federal bills that this refers to. COPA has a section that allows an entire industry to have what's called safe harbor, to negotiate directly with the FTC to come up with a set of rules that allow them to govern this process. And the way that I read that legislation, it says that there's only 3 sections of that bill that they have to comply with to have stronger standards. Well, what about the other 10 sections? And I think what this really boils down to is what you see at the federal level. And I believe, just again, genuinely, I think, maybe this is true. I'm making an assumption here, but my guess is that the bigger problem here is that we're having to negotiate with very large corporations like Microsoft to negotiate data privacy laws. It is a basic function of privacy in this country to have privacy. And the issue that we have now is without privacy, we have no liberty. And so the reason why this bill is so important at this critical time is the risk of data privacy is not that we'll lose our identity or that we'll have identity theft. What we're talking about now and what the very large corporations are talking about in public meetings at the World Economic Forum is they want to directly govern people. Corporations, 1,600 of the largest global corporations in the world have the largest asset managers in the world, 3 of them, control 8 to 15% direct shares of 1,600 global corporations. It's not as if Microsoft is in this building now negotiating on its behalf to have some kind of unfair competitive advantage against its competitors. It's that there are asset managers that are trying to dictate ESG policy that have direct ownership of the top 3 or 4 competitors in every major vertical. The concern with data privacy is now discrimination. For Republicans and Democrats, this is a nonpartisan bill, and so I completely respect that the stakeholders include corporations, but I'm sorry, Microsoft and these other companies require you sign a consent form for you to be able to conduct business with them. That's not non-coerced consent. That's not respect for consumer privacy, right? How are you going to say no to Microsoft if you got to show up to work? And the problem is that the corporations are what I see as really a virtual monopoly. And so I'm going to make a suggestion here about how to approach this, but again, I genuinely am coming from the perspective of a constitutional perspective. The only way, financial conflicts of interest are the biggest risk to our democracy and to our public health. And I say that with very clear language. There's no question about it. The FDA receives 45% of its funding from pharmaceutical companies. The administrative layer of our government passed 200,000 regulations in the last 10 years, and Congress has only passed 10,000 laws. What that means is 20 times the amount of rules in this country are being passed by non-elected regulatory agencies that are completely in bed with these big corporations. And so the only way that we can change the orientation of data privacy is to empower the individual. The consumer owns the data. And unfortunately, this bill and many others that I've seen, and I read a few last night, come from the orientation that the corporation owns the data. And as Mr. Perkins said so eloquently, you're in a situation where you're assuming that an individual has to go and grovel for their rights with 20, 40, 50, 100 different service providers that they're doing business with. Opt-out assumes that the corporation is in control and has all the leverage. And I want to be really clear. I am an entrepreneur. I am pro-business. But we have to, in this country, take the stance against corporations violating our private individual rights. It is a right of American citizens, and certainly Texans, to have their privacy respected. So with all due respect, I believe that the only way to address this issue, I thought about doing a red line, but unfortunately I just cannot see how to approach this with any other way except what I would consider a very short and concise bill. Save and accept the definitions, which do require a lot of effort and energy, and I understand how much negotiation is happening here. But the bill that I would propose is very simple. It says that the consumer owns the data. It says that if a business is going to use data for any other purpose than conducting business directly with their customer, then they have to get non-coerced consent. It's as simple as that. If they sell the data, they ought to provide some form of reasonable compensation, although I think that that might muddy the waters here. But at the end of the day, unless we are truly looking to empower the individual, to give the consumer its power, to respect its constitutional power, all we're doing is codifying in law that the corporations have the way to violate this. And again, the numerous federal laws that this refers to, whether it's HIPAA or financial data, there are loopholes in that allow these corporations to conduct business the way that they want. I read an article, I'll wrap up here in a minute. I read an article last night from a Democrat who was on the FTC, which governs COPA. He was on the board, who said that he was concerned that the FTC was completely compromised by the big data companies, which is not a surprise. And I would ask you to consider whether Google and Facebook are respecting our privacy now. And I think everybody in this room understands and knows the answer to that question. So deferring to federal law is not respectful of the values of Texans. And I believe that the only way that we can fundamentally address this issue across the board is to assume that the consumer, the Texan, owns the data. So I would be grateful to share my limited experience to discuss any of this with the members of the committee. I also want to say that I know that there's been so much energy put into this, and I genuinely understand the gravity of how difficult it is to have negotiation with the stakeholders. But the reality is we're in a situation now where we started with the Constitution, and now we have corporations that are stakeholders to tell us what our rights are. No, thank you. We have rights. We need to enforce and make it very clear that our privacy is ours. Your blood, your genetic data, your biometric data belongs to you, not a corporation. And until we make it very clear and explicit that the individual owns their data, we will never be able to address this and protect our rights, because the risk is not longer that you're going to have your identity stolen. It's that a corporation will tell you how you can use your credit card. We are about to move from a situation where these corporations not only have our data, which this legislation would now allow enough of, it does provide protections, but because of the references that it makes, it also provides a lot of loopholes, just enough for the corporations to have what they want. Combine that with the unique digital identifier, and we will see tyranny. Mark my words. The Federal Reserve is already talking about using their digital currency as a way to determine what people are spending their money on. Have you met your carbon credit requirements? Do you agree with their political opinion? And even if we think these for-profit corporations can dictate social behavior and ethics, it's for profit. And the minute the wind changes, they will start to discriminate against you. We cannot give corporations the power to dictate and enforce what social rules are, and giving them access to our data and giving them digital identifiers, which we all need to be opposed to, like digital driver's license, is something that we should all be very careful about. So with that, I will say thank you so much for allowing me to share. I welcome any questions, and if there's anything that I can do to participate in the conversation, again, I would be glad to. And again, with all due respect, I know a lot of effort has been put into this, and this train is rolling. But again, I'll state very clearly, without privacy, we have no liberty, and the only way to accomplish this is to empower the Texan to own their data. Thank you.
Representative Lambert.
Thank you, Mr. Chairman, and thank you for your testimony. I just wanted to compliment you on your parenting skills. Your two children have behaved admirably, and I just want to compliment you on that.
Just wait 5 minutes.
Representative Frazier.
Hey, just one quick, Mr. Porter. Where did you say you're working at?
I'm an entrepreneur, but I had my previous, the first job that I had out of school, I worked for a company called the Wheel Group, and they created network security platforms, basically, and they were purchased by Cisco Systems. So that's kind of my, again, I don't claim to be an expert. I just have a little bit of experience in terms of the technology world.
I got that, but I thought when you first started, you were representing a group.
Oh, I formed a group called Texas for Liberty, but I'm really here on my behalf, yes. And also a group called, I'm a co-founder of something called Texas Liberty Council. Yeah, but we're, and I seem to be the de facto person that's interested in these data issues. Yes.
No problem. I just didn't catch that at first. I appreciate it. Thank you for your testimony, and I agree. Very good parenting skills.
Thank you. Thank you guys for being so patient with us here.
Members, any questions? Thank you very much, Mr.
My
Porter.
pleasure. Thank you.
Chair now calls Servando Esparza. And we show you registered as Servando Esparza on behalf of TechNet, and you will be testifying for the bill. Is that correct?
Yes, sir. Chairman Longoria and members of the committee, for the record, my name is Servando Esparza, and I'm Executive Director for TechNet in the Southeast region. I'm testifying today in support of House Bill 4. TechNet is a national bipartisan network of tech companies that promote the growth of the innovation economy nationwide. Our member companies place a high priority on consumer privacy. The technology industry is fully committed to securing privacy and security for consumers and engages in a wide range of practices to provide customers with notice, choices about how their data is used, as well as control over their data. We appreciate the process that Representative Capriglione has taken on the approach to House Bill 4. As has been expressed, he's been working on this issue for several years, several sessions. We have probably provided a ton of that over the years. And so while House Bill 4, the committee substitute for House Bill 4 doesn't include every single thing that we'd asked for and recommended, the reason why TechNet is supportive is that House Bill 4 takes into account the interoperability. That means how the bill works with other states' laws on this issue, which makes it a lot easier for companies to implement these types of of rights and comply with it much easier, while at the same time providing the important privacy and security rights to consumers. While the bill or the committee substitute is roughly 35 pages, the importance of every single definition in there, I know we had plenty of conversations about what if this is modified slightly. That's why a lot of the feedback has been about the definitions and how they sort of compare to the Virginia law that exists. Any minor change to that is something that we watch closely, because one change of the definition means in the operations of how the bill works might change sort of drastically. And so we watch that pretty carefully. And it could affect consumers and companies in a number of ways. In certain ways, any change that's different from the provisions from other states, that includes Virginia, means some increased compliance costs, which is what we're looking for. And finally, I just want to sort of note that the last witness mentioned a lot of different federal laws, and what Representative Capriglione has done is on acknowledging that there's some federal laws that do preempt the state. He has been able to sort of create a bill that consumer groups and others can support, and that the business industry is sort of comfortable with, because of, at least for TechNet, the importance of the interoperability of the law. So I appreciate that and happy to answer any questions.
Thank you, members. Any questions? Thank you very much.
Thanks.
We have a resource witness, someone, Stephen Robinson from the Office of the Texas Attorney General, Consumer Protection Division. I don't know if any of the members wanted to call them up for any assistance. All right. Is there anyone who wishes to testify on, for, or against House Bill 4? If not, the chair recognizes Chairman Capriglione to close on HB 4.
Thank you, Mr. Chairman. Members, before I close, I just wanted to first thank you for hearing the testimony and hearing about this bill. We have worked over the last few years with over 200 stakeholders, and we've taken this bill from what it was 6 years ago and significantly strengthened the bill, while at the same time looking at what other states are doing. And I would say that other than a handful of folks, we've been able to not compromise, but get others to compromise on that bill. Do I wish I could pass a law to stop all the data from having left the barn? Sure. If I could, I would do that, and you would all support that, right? But every single minute of every single day, data is being collected on you, whether it's through your cell phones or through your cars or through the restaurants you eat, your credit card statements, constantly, you and your family, every single second. So what this bill does is it not only strengthens the data that is already out there about you, strengthens its storage and how it's being handled, but also on how that data is being processed. Because between now and now, more data has been collected about you. And what we're trying to do is make this bill as effective and as powerful as possible so that you have that control. Do I wish we could preempt federal law? Sure. I wish we could. But those federal laws have preemption in them. And so what we're doing in this bill is filling the huge gap in this state between those laws. Our definition of consent specifically prevents coercion. So I know someone had mentioned that, but our bill addresses that. Our bill says you cannot discriminate against an individual who does not want their data being collected. Some of the most important information, and I know for some of you, if this is the first time you're looking at this kind of stuff, we protect sensitive data. This would be the first time that we're protecting personal, private, sensitive information, requiring you to opt in. To give you an idea what sensitive data is, it's personal data revealing racial or ethnic origin, religious beliefs, mental or physical health diagnosis, really personal information. We've gone past and beyond Social Security numbers. You could buy that for $1.25, by the way, on dark web. Your Spotify account is $3.50. The PayPal details that you have is $15. Your health insurance information goes for a little bit more. What our bill will do And what this bill would do is it will make the strongest data privacy laws, and I think will ultimately be the model for the rest of the country. Continuing technological innovation in this country while finally putting the control of the data in your hand. With that, happy to answer any questions.
Thank you, Chairman. Members, any questions? Thank you.
Thank you, Mr. Chairman. I close.
The committee substitute to HB 4 is withdrawn. If there's no objection, the bill will be left pending. Is there objection? The chair hearing none, the bill is left pending. Well, members, that concludes today's agenda. Is there any further business for the committee to address? If not, the chair moves to adjourn. Is there objection? Hearing none, the committee stands adjourned, subject to the call of the chair.